So I'll just introduce you.
Sure.
So good evening, everybody, and thank you for joining today's session. My name is Sapna. I'm from the admissions office, and we have Professor Nirish Grover with us. Uh, he teaches in the School of Policy and Governance. He himself is a lawyer, has practiced in the High Court and the Supreme Court, and has been teaching law at the, amongst other places at Azim Premji University. So he is an authority on the subject. He will be happy to share with all of you the structure of the program. What to expect in the 1 year that you will be with us if you join the LLM course with us, and he will, at the end of it, he will also take questions from you, right? So that is it. Over to you, Niraj.
Thank you, Sapna, and welcome everybody. First of all, thank you for showing interest, and also thank you for taking time out to listen to me and about our LLM program. I will try and speak for a brief, I call it brief, I don't know, depending on the monotony of my voice. For you, it may not be so brief, but I will try and speak for first 20 minutes or so, and then we reserve some time for questions and answers to make the session more interactive. And it is through the process of questioning and answering that perhaps we'll get to know more about the LLM program. So as you know, the subject of today's conversation is the Masters in Law program at Azim Premji University. In my introduction, I will try to talk, first of all, briefly about the subject area that the program covers, which is law and development. Then about what is the approach of how we teach the subjects in the program, and in other words, what's our pedagogic approach in the program? And then briefly tell you about the structure and design of program's curriculum, and end with some sense of what's the outcome of reading an LLM with us and in law and development. And when I say outcome, I will mostly talk about learning outcomes, and perhaps share a word or two about what our alumni has been up to, generally, not too much in detail. And that, I hope, will be a good 20 minutes of introduction for you. Okay, now to set the stage, let me just briefly talk to you about what is law and development, because that happens to be the focus area of our LLM. And our LLM is not so much a specialization as it is a focused LLM. So there's a very minor technical distinction. It's a general LLM, technically speaking, but with a focus on law and development. So as an area of study and inquiry, law and development is very vast. In fact, it's only recently that development has become such a buzzword. When academics say recent, their idea of recent is fairly broad. So I would even count the last 10 years, the last decade, as included within the idea of recent times, right? So particularly in the last decade and a half, we've seen how frequently development has become often used as a lay term. Many people have invoked the use of development as a political rhetoric. It has been one of the key components of election agenda, at least for the last 2 elections. Elections have been fought, won and lost on the basis of views of development, and at least the invocation of this idea of development. So that makes it all the way more relevant to inquire into what does it even mean. And that is where, as an academic, we see that the waters are far more complicated than it is made out to be in popular culture. When one starts to inquire and get to the root of what they mean by development, one of the most easy things to observe is how different and diverse people people's views on development are. For somebody, having very nice malls around wherever they stay could be a sign of development. But for some people, having good roads, infrastructure, flyovers, parks, and other public infrastructural spaces could be a better sign of development. And for other people, malls and roads may not matter so much as state's provision for the downtrodden and the poor and the disadvantaged people of the society. Those things they count. Some people count as better metrics of development. So equally diverse, and one when starts getting further into these ideas, it becomes far more evident that people are not really sure of what they mean by development. Sometimes I'm not saying everyone who's using development isn't sure about it, but I'm only saying that there are multiple ways of looking at it. And when one finds it very, very tough to figure out what exactly is the correct and the most appropriate way to look at development, just even from an academic point of view, from a policy making point of view, what should be the state's focus? What should be the state's priority? Should it be development of markets? Should it be development of infrastructure and roads? Should it be development of social services? What should the state prioritize? And this becomes even more important in a country like India that has limited resources and that has to prioritize things. And often, to prioritize one component of development comes at an opportunity cost of deprioritizing some other element of development. So it's a very topical subject area of inquiry, specifically from an academic point of view, because even though the usage of the term has been prevalent, as I said, in the last decade or so in pop culture, it's not been so well inquired, at least academically. People are debating this in literature, in scholarship. There are many, many ways of looking at this, and every author brings, or every academic or theoretician brings their own specific points of views of what constitutes development and what should be the developing countries' priority as they launch towards their own development trajectories. Now, that's insofar as development is concerned. But what makes it even more complicated is what is the relationship between law and development. So we know that by itself development is the priority of our country, at least right now. But how, as lawyers, can we think about development? Where do we see law assisting development, and how so? And again, the most repeated answer to that question is that good laws can mean good development. Any law should follow the virtues of equality, non-discrimination, should enshrine basic human rights and stuff. And that's how a good law can make for a well-developed society. Many people actually go so far as to say that in order to develop, we must have a strong rule of law system with notions of equality and non-discrimination embedded within it, so that our country can be a equal and virtuous society. But then when we start to really take off some of those layers and start to inquire, we see that it's not actually that simple. Because first of all, of course, everyone agrees that laws should be equal and laws should reflect values and virtues of equality and non-discrimination and such. But in a country that has as complicated a social structure as India has, it is not just enough to say that law should reflect equality. Because when we start getting deeper into the ideas of what is positive affirmation, how can the state involve itself in uplifting the poor and the disadvantaged, and what basically should be the role of the state? How should we decide? And these kind of issues keep coming up. They come up in the litigation on reservation that we've seen last year. They keep coming up in the current ongoing litigations. And one, as I'm assuming that most people out there who are live with me now are lawyers, so I don't need to reiterate how complicated the issue of equality can get beyond just saying this. So there is no disagreement right there, but complications arise when one starts to look at specificities. The devil is in the details. And in that sense, take Sabrimala's case, for example, right? There is a religious question about whether women should be allowed or not. The Supreme Court sits and says, yeah, well, they should be. And then we see the women who are supposedly the beneficiaries of that judgment say that, no, this is not what we want to follow. We want to stay out of it, at least a group of women. So it's complex. And in this kind of a complicated, structured, very layered society, we are talking about good law makes good development. So what is good law? How do we come to realize that something that just says equality is good law by itself? Go more than that. Law has to factor in social realities, political realities, and then how those social and political realities translate to a legal reality is a very complicated question. Necessarily, though, equally complicated question is how people perceive law. What is their idea of what law is? I mean, we do have equal laws. We do have laws that are, in some senses of the word, embed the most basic values of human rights. We also have laws, fundamental rights, no less, that enshrine these principles that we talk about, and we would definitely look at it as good law. But then we continuously face the issue of translation. And by translation, I mean, how do these good laws translate into a reality, into a social reality, right? How do provisions that relate to positive state affirmation or reservation, etc., translate to a reality where social hierarchies are narrowing in one sense? But then that also leads us to believe, well, if we go to a village, how do those villages in India, remote locations that don't have access to justice, what's their perception of law? And we realize that they really don't look at law the same way as a cosmopolitan or a metropolitan citizen of India does. And there's a complete variation in the way we perceive law and legal institutions. I mean, if you go to a city that is completely remote and is more enmeshed into the local culture, into the norms and values of history and custom, you will see that the reliance on legal institutions and courts is far less than, say, reliance on legal institutions that businessmen in Bangalore have. Right? And these perceptions about how citizens perceive law, about how citizens perceive institutions, play a very important role in figuring out what is the relationship between law and politics and the society. So that brings me to my basic premise, which is when people say, and when lawyers, fresh law graduates say that good laws mean good society, we have to really question that on many counts. First of those questions should come from the angle of what constitutes good law. Second of those questions should come from the point of view of how does, even if you have good law, how does that translate to a social reality? And the third of those questions should come from, even if the law is translating a society into reality, what is the opportunity cost of that good? What are we losing in the process? There's always an opportunity cost. And it is these kind of questions that motivate us to go to the field of law and development, because it's a field that looks at the relationship of law with the society. By its very nature of inquiry, the whole field of law and development is an interdisciplinary field. Naturally, any LLM on law and development, therefore, is an interdisciplinary LLM. And that is a unique feature of our LLM, that it is interdisciplinary. We don't look at law from a very technical point of view. Of course, we look at statutes, we look at case laws, precedents, those things naturally come to us as lawyers, but we go a step beyond. We try to see that, okay, law has its limitations. So we try to see that with those limitations, how does the law relate to, say, political institutions in the society? So what's the relationship between law and democracy in India? What's the relationship between social hierarchies such as caste system and law in India. So we look at these social phenomena, we look at the institutions that are embedded in the society, kind of institutions and practices that are born outside of the legal system, and then we look at legal systems and we look at the relationship between these legal systems on the one hand and the non-legal systems on the other hand. We assume in our study that the source of norms in a society, what are norms? Norms are basically things that tell you what you ought to do or not ought to do, right? So we assume that the source of norms in any society is not limited to legal and law institutions. We assume and we understand and appreciate that these norms also come from culture. These norms also come from political institutions, from markets, from economics. And we then see that law is only one amongst the several sources of these norms. And it really depends on how law relates to these other systems in order to figure how the society is functioning. And that's why when we look at development, which is essentially an idea about how a society should be, when you talk about development, you're talking about where the society should head towards. It's in a sense study of the society. We have to appreciate that law has a limited but an important role to play. And in order to completely understand that society, completely get to the core of understanding what development is, we have to also understand how do these legal institutions relate to political and social institutions. So if you're applying to this program or if you're interested in the field of law and development, you have to appreciate that it's necessarily an interdisciplinary inquiry. That brings me to our pedagogy. So what do we expect from you? First of all, we expect that you will admit with open arms that good law doesn't automatically mean a good society. That's the first requirement. Second, we want you to be open towards reading things that are possibly slightly out of your comfort zone. Undergraduate studies in law are very doctrinal. They're hyper-technical, right? You're continuously throughout your 3 years or 5 years, depending on the nature of law program that you graduated from, will require you to read immense amounts of statutes, case laws, and this and that. And it places an immense amount of reliance on technicalities of law, right? What this LLM program does, because of the nature of the interdisciplinary inquiry that law and development is, the LLM program asks you to read not just very technical legal texts, but also law and economics literature, also literature on law and society, literature on how social norms and social customs relate to law, right? So many of these scholarly work will be outside of the technical domain of law, which then informs and enriches the understanding of legal institutions, right? So that's the unique feature, and even at the faculty level, we see that most of us are interdisciplinarity oriented members of the faculty. So some of us are not really lawyers. We've got economists, we've got sociologists, we've got anthropologists, people who are outside of the domain of law, experts in their own respective fields, but necessarily engage with the LLM program full time. And that's the beauty in some ways of our LLM program. At least for me, that's a major motivating factor to go to the classroom or go to the library every day or go to faculty meetings whenever they happen, because they allow me to look outside the hyper-technical window of law and to indulge with a far wider and a far richer area of literature that's just not limited to statutes, case laws, etc. Now, and that completes the first part of my talk today, which is the introducing you to the field of law and development, very, very broadly, but nevertheless, in some manner, letting you know what is the nature of the field. And then the second part of my talk is about the pedagogy. So how do we teach? Of course, one thing we don't do at the LLM program, and something that we consciously avoid doing very, very much, is to not follow the sage on the stage model, right? We try to not look at instructors or teachers inside a classroom as if this person is someone who knows more than their students and just standing and teaching from a height. We don't believe in that. We think that classrooms are places of important dialogue where knowledge is shared. Knowledge is not just only shared and applied, but also constructed right? In the process of sharing of knowledge, we feel that we build newer forms of knowledge. And to us, classrooms therefore serve as spaces of collaboration. Of course, there's some sense of hierarchy. The very process of education, to an extent, involves a very minor flavor of paternalism. There is very little sense of hierarchy, but to the extent that we can avoid it, we do avoid it. And we make classrooms discussions and interactions rather than lectures and monologues. So there are two elements. I think by and large, there are two important elements of our pedagogy that I want to share here. The first of those is what we try to do is we first of all try to introduce to you the theoretical array of the subject that we are teaching. So suppose you are learning, say, a law development, the core subject, flagship subject of our LLM program. You will be introduced to the range of debates in the field. What are different authors saying? What are the points of inflection and deflection? What are the points of contradictions? How can we make sense of these contradictions and reconcile them? How do we apply them, right? So first of all is introduction, right? This is basically helping you understand. So we take the theory, we take the literature, we take what other scholars who research for years on their respective subjects, we take what they have said, we deconstruct them in the classroom, right? We give you readings. Every course at the program will have specified readings that you'll be required to go through in advance of the class. Or we expect all our students to have well read the reading for each class and come to the class. On the basis of these readings, we then start the discussions, right? The students ask us questions on things they did not understand about their readings. They ask us questions on what are the doubts they have on the reading. So the first element that pedagogy is introducing, we introduce this literature to you, we introduce this debate to you. And the second part of pedagogy is helping you engage with it, right? So introduction and engagement. Engagement is an important part because this is where we ask you not just to be introduced to the literature, not just to be introduced to the scholarship, but also to be able to make sense of it and apply this scholarship. So if, say for example, some author has said that democracy is good for the markets, right? Now having introduced to that literature, we would, hello? Sapna, am I audible? There's a circle here. Okay, back. Okay, so in addition to being introduced to that premise that good democracies lead to good markets and vice versa, whatever, we also ask you to apply it. So take, for example, a country like India, how true that thesis holds for Indian situation, how true that thesis holds for Japanese situation, right? Which is a very unique place of development. Wait. Just give me a moment. Sapna, this keeps going. Am I also getting disconnected or is it just my computer? Okay, good. Thank you. All right. So, sorry about that. So there is the second element of the pedagogy is engagement, right? You're not only being introduced, but we also help you to engage. One thing that we hold really close to our heart in the second element is creativity. So we don't want you to only take knowledge and apply, but we want you to ask questions, to be inquisitive, to be curious, to be interested in what do you think about the premise that you've just been introduced to. And in this way, we encourage you to not doubt yourself. We encourage you to bring your thoughts to the class and bring your thoughts to the discussion and help us also build on what you're sharing, right? And that's how we aim at constructing knowledge, not just sharing knowledge inside of a classroom. So that's broadly our pedagogical approach. Even our exams, evaluation patterns are designed keeping in mind these elements. We don't look at exams as a basis to test the student, but we also look at exams as a way to help our students think critically about something they've been learning in the classroom for so long. And that's so far as our pedagogy is concerned. Now, let me just move to the third element of this talk. So we've got, first element was introduction, where I tried to introduce you to the field of law development and the context of our LLM program. The second was the pedagogic approach, how we teach and look at classrooms. And the third element, which I'm going to talk about now, is our structure and design of the curriculum of our LLM program. So it's a one-year program. 1 year is divided into 2 semesters. Each semester you study a few courses. That's by and large of it. And there are two elements of the program that run throughout both semesters, right? Okay, so the first element of the LLM program are taught courses. Obviously, it's an academic program, has to have courses. The second element of the LLM program is a research and dissertation element, right? This is where you write a 10,000 words research thesis throughout the duration of the LLM program, and you present and defend this thesis at the end of the program. This is a supervised project. So you work in supervision with a member of the faculty, in consultation with whom you choose the topic of your project. They approve your project, they guide you. And by guiding, we don't mean they spoon feed you. The autonomy and the decision to write the project and the burden and onus of writing that project is completely on you. Your supervisor is only there to course correct you. Where they see that you're entering into a wrong line of inquiry, or where they see that some line of inquiry is worthy of being pursued, they introduce you and help you to push you and nudge you in those directions, or to pull you back from directions where they think research is going in an absurd way, right? So they are basically the supervision. We look at supervision as course correction ways, where we correct your research trajectories rather than spoon feed you. So that's something you do. You write a 10,000 worded research project, which is supervised, defend it at the end before a panel of faculty members. That does not include your supervisor, and then get an approval. So taught courses, research and dissertation, and then there is a third component. And this component is what we call field practice. Field practice means, and this is something also you do throughout the year, but unlike dissertation, field practice is something you do in groups. I don't know for how many of you that's happy news, but this is basically a group of 5 to 6 students drawn not just from LLM, but also a joint program that is policy and governance program. So students from policy and governance and LLM programs are divided into groups of 5 to 6 people. They then, as groups, choose the project that are on offer. So these field projects basically are projects that faculty members offer. So for example, I might offer a project on, say, citizenship. Somebody else, one of my colleagues might be offering a project on human rights. A third colleague might be offering a project on, I don't know, democracy. So these projects are on offer. The groups of students, the groups that we divide you into, each group applies for the project of their choice. Actually, each student applies, and then we divide you into groups basis of your preferences, right? And then as a group, you work under supervision of the faculty who offered the field project, and throughout the year, you engage on the topic of that field project. Now, what do I mean by engaging? So, unlike dissertation, field practice, as the name suggests, is not a very theoretical exercise. What we try to do is say, suppose you are taking a project on citizenship. What your faculty member will tell you is to have you pursue the relevant literature on citizenship first, then find questions that you think are better answered by going to the field, and then collect the data from the field, come back to the classroom, and apply that data to supplement the theoretical framework of the topic of your field project. So I'll give you an example. So take, for example, a couple of years back, I'm familiar with this project because I supervised it. There was a project on housing rent discrimination. How in Bangalore, people who are single face discrimination on housing rent versus people who have families or are staying with their partners who are married. And then the 6 students who were part of the group, they reviewed the necessary literature, authors who've written about this issue in law journals, in newspapers, etc., or books that have addressed this issue. Basically, pieces of scholarship that have researched and published that on the topic of this, their choice, which is housing discrimination. And then they take questions from that literature, which they think are best answered, and then they go to the field. Field for them would be, they choose an area within which they'll go ask the people, what do they think about discrimination, collect data, whether there were victims of discrimination or whether they have, as owners of a property, ever said no to somebody for rentals only because that person was not married or was single. And then they take that data, then they come back and apply that data to the literature and say, how does that benefit the literature? How does the data from the field? And then come up with certain proposals or some thoughts on what they think the policy and or law on the subject matter should be. That's how field practice is done, right? So we expect that of the entire year, you will work also on your field practice, and you will at least have to spend 21 days in between the semester breaks where you go to the field and collect this data. That's insofar as field practice is concerned. So just to revise, 3 components. One is, of course, coursework, taught courses. Second is your dissertation, 10,000-worded thesis. Yes, you write as an individual in supervision. And the third is field practice, which you do in groups under supervision also. So these are broadly, this is broadly how we design the curriculum. Now, when it comes to courses, there are 2 semesters. The first semester has 3 core courses that you mandatorily have to read. And in addition to these 3 core courses, you will have to pick one elective course. I mean, you will still have to pick a course. The only difference compared to core courses is that you have autonomy to pick the courses. Right? So there will be 4 to 5 courses on offer, and you can enroll for one of them. And that's why we call them electives. So 3 core courses and 1 elective in the first semester. And in the second semester, you've got 1 core course and 2 electives that you have to choose. Now, first semester core courses are, of course, the flagship course of the program, which is the course on law and development. And then the second course on law and justice. This is also an interesting course. Law and justice looks at the variable concept that justice is, how fluid and how variable notions of justice is, right? It deconstructs this idea. What is just and what is unjust? And it tries to draw parallels on what is the source of these notions of justice. Where do they come from? Do they come from culture? Do they come from law? Do they come from an external culture? Do they come from scholarly writings? Do they come from religion? So those are the kind of questions that law and justice engages in. And that's so important, because when we talk about law, we always keep invoking the notion of justice, right? And that's why this course is beneficial, because it takes that notion of justice and it helps you deconstruct it to find sources of that justice, and also helps you draw parallels on how the concept of justice is connected to other concepts like religion, culture, and stuff, right? So that's law and justice, which is a core course in the first semester. A third core course in the first semester is research methods. And that's a course that tremendously helps our students in writing their dissertation. So this course basically tells you how to inquire academically. What are we doing when we are researching, right? End of the day, when you're writing a paper or a thesis, what you're trying to do is you're trying to look for truth. In between all these scholarly articles, research, law journals, and books that are relevant to your research, what you're eventually trying to do is to arrive at some notion of truth that's out there. So either you pick up the knowledge that's out there and apply it to a newer situation, and you say that that's what it is, that's the correct way to look at it, or you find loopholes in the current literature and you point, and that itself becomes a contribution to the scholarship, because you say that, okay, this is out there, but there is a serious flaw with it. So eventually, either which way, you're trying to figure out a proposition that is true. Right? So what research methods course does is to introduce you to how to ask questions. What kind of questions are academic questions versus, say, journalistic questions? There are certain questions that we can ask as citizens of the country. There are certain questions that a politician can ask. There are certain questions that a news anchor can ask. But when you're in an academic space, as a lawyer or as a researcher, not all of those questions can you ask. Right? You are only allowed to ask questions within a set framework to maintain the integrity of your research. Right? If you approach issues of, say, development, you can't just say that malls are good for development because ABC. You have to base it in a theoretical framework to justify that proposition. So that's what research methods help you do. It helps you find out whether the question that you're asking is academic enough, and what is the nature of this question, how should you pursue in answering it, How should you structure your writing? What is the framework within which you should base your academic research? That's the third core course of the first semester. And of course, I've not said much about the flagship course, and I'm going to not say about it much because I thought some of it was part of my introduction of the program itself. So, and in the second semester, you've got one core course, which is Comparative Public Law. It basically compares the public legal systems like constitutions across jurisdictions, right? We think it's an important course to introduce our students to, because we think public law systems play an important role of the development trajectory of any society. So, all these are core courses. Our electives are all interdisciplinary, keeping in the nature of our program. So you have electives on, say, the nation and the state, law and the nation. You have electives on nationalism. You have electives on climate justice. You have electives also on corporate governance, on foundations of private law. And each of these electives look at law from the outside, right? They try to see and answer the question of what is the relationship of legal institutions with other institutions. So even when you're studying a subject like foundations of private law, and we look at concepts such as ownership, property, transfer, liability, we look at these concepts from a very philosophical point of view, right? What is the theoretical grounding? Where does the idea of ownership come from? End of the day, we figure that some of these ideas in private law that we take for granted are actually based off ancient religious texts, or are based out of very Western cultural notions of fairness. And those are interesting revelations, right? Because it helps us understand that law is not a self-standing system of morality. It looks out for its sources of legitimacy and morality sometimes. And that's how most of our electives are designed. And I hope that if you're interested in interdisciplinary inquiry, you'll pretty much like almost all of our electives. Okay. So that completes the third element of my talk, which is the structure and the design of our curriculum. And now I come to the last element of my talk, which is the learning outcome of the LLM program. Why should you want to do an LLM program of this kind? First, of course, because in the development discourse, what has happened is for the longest time, much of these discussions have come from the West, right? So starting from 1960s, post-World War times, most of these ideas about how the market should be, how a country should be structured, how political setup of a country should be, how federal, non-federal, what kind of goals a state should pursue, all these things are the ideas basically developed from a conversation that originate in the West. Developing countries have had to look out. And I think this is a beautiful opportunity to discuss these questions sitting right in a developing country, right? So even the nature of discourse is changing. Over the last 5, 6 years or 10 years, we see an emergence of scholars from the developing world, what is in academics known as the global south. Scholars who are trying to espouse and argue for indigenous ideas of development. People are trying to question that more employment and more growth does not always mean good development. So we have to look at at least we have to be open at examining other points of views. And that's something that I think this course presents a golden opportunity for. It's not a course situated in a Harvard or in Oxford where in an ivory tower you try to look at countries like countries from the global south and try to see how they should or should not develop. It's more indigenous and authentic in its in the sense of where it's situated. But that may not appeal to everyone because it's not the most pragmatic reason to suddenly get up and try to do an LLM program. The second reason I think why you might be excited about this program is because it presents you the opportunity to look outside of the law while very much keeping in your identity as a law academic or a lawyer, right? It allows you to understand how outside institutions shape the law that you've read for 3 years or 5 years. What is the effect of political and social landscape of a society in the kind of laws that the society has? So that's that intellectual curiosity. If you have, then this course is a golden opportunity to somewhat create that curiosity, to ask questions, to become sharper at debating things, to become better at analyzing and questioning things, and more importantly, to contribute to the development discourse of the country from a academically informed point of view, not from a journalistic point of view, right? So that's the second. The third learning outcome, and this I think is most often asked, is more pragmatic outcome. Right? What are the nature of opportunities available to me after I finish my LLM program? And I'd look any LLM program in the world. I think it's my personal view, and in this I'm not speaking on behalf of the faculty at large. I think any LLM program in the country or in the world does not substantially change the nature of opportunities available to you compared to the nature of opportunities that were available to you after you graduated in law. So at the end of 5-year or 3-year law course, the kind of opportunities that you have are going to be pretty much similar to the kind of opportunities you have after an LLM too. And that holds true for most LLM programs across the world, right? Pragmatically speaking, if you do an LLM, say from a very Ivy League or some Oxbridge kind of institution, maybe there is a branding value that might open up some opportunities to you or not. But that's a very, very pragmatic and a very different way to look at it. We are not chasing that here, and that's never been on our agenda also. But to give you a sense of what kind of stuff that our students have done, so the most important sector where our past students have gone to is actually academics. We are very, very proud to say that. What our students are trying to do, and most of our alumni are trying to do, is to go to undergraduate law schools and contribute in changing the way law is taught to the undergraduate students, to unshackle the law from its hyper-technical pedagogy, and to make sure that law is more than just a set of statutes and precedents, right? And that's something that we are very proud that our alumni has been able to do. The second sector where most of our alumni have gone is litigation, a place where law matters the most and a place where social change also happens in many ways, right? Some of them have picked up cause lawyering, have argued important PILs. Some of them are associating with organizations and bringing the cause to the court, at least making justice accessible in their own unique ways. So that's the second place. A third and interesting space is think tanks, social sector, policy think tanks, and field institutes, places that do field work or places that do research work and policy work. That's another sector that you can look at. But above all, if you wanted to go to a place after your 5 years of law graduation, that opportunity still remains open after a 1-year LLM. And you can always go back there, except the difference will be that you go back to that place with a far wider intellectual array of acumen than you would have had prior to this. So I'm not trying to say that people who graduate just with an LLB have any less intellectual acumen. I think there are many people out there far sharper than of us combined here at APU. It's not a temple of intellectual superiority that I'm trying to portray here. But all I'm trying to say is at least we try and have these conversations which helps both grow, people like you and me, when we try to look at subjects like these that are very, very topical in today's time. And with that, I will end and pass it on to you back again for questions and answers. Thank you very much for your patient listening, and I hope that I was clear, accessible, and you understood the message that I was trying to communicate. Thanks.
Thanks, Niraj. Very, very insightful presentation as usual. Yeah, I've done this before, but I learn new things every time. Uh, and there are a couple of questions, and my request to the listeners, the students who've logged in, is to type in your questions in the chat box. I will then read them out so that everybody gets to know the question and the answer. Right? What we have already is one which is relevant directly to what you were saying. To what extent is the practice of a legal academician different from that of a practicing lawyer?
Sorry, can you repeat the last bit, Sapna? I lost you.
to what extent is the practice of a legal academician different from a practicing lawyer?
To
The
what extent is a legal academic different from a
yeah,
practicing lawyer?
from a practicing lawyer. Yeah,
Well, in many
and
ways, similar to, but different in the sense that um, a practicing lawyer's focus is more on a very narrow outcome of the cases that he or she is arguing or they are arguing, and that's justified in the role that they play. But to the mind of a legal academic, that there's always two things. One of the curiosity and the hunger to understand a certain social phenomenon, which is to look at society, to look at a certain phenomenon in the society, and to merely understand it better. And in that sense, the acquisition of knowledge that a legal academic has, his or her or their way of acquiring knowledge is intrinsic, which means that their way of acquiring knowledge is for the sake of acquiring knowledge, for the sake of adding depth, um, but as opposed to an instrumental way of acquiring knowledge, which is acquiring knowledge as a means to achieve some other external tangible goal, which is to get favor the order for the clients or to help your clients, basically. Somebody who might as well be denied access to justice, right? So not these are the instrumentalization of knowledge versus having knowledge uh, for the curiosity of having it and for the idea of adding to the scholarship so that others can understand and share that knowledge and build more upon it. That I would say is the primary difference.
yeah, that's right. Good, thanks. There are a couple of very sort of pragmatic, practical questions. Will it be possible to work along with studies in this course?
Absolutely not. The one thing that I emphasize very much every year, and this time I forgot to emphasize, is that our LLM program is hyper intensive. Look, we are trying to maintain and achieve a certain sense of quality into the program, right? And we're also trying to do too much in one way. We're trying to pack this program with not just law, but other associated disciplines too. And what that means is that throughout the 1 year that you spend with us, apart from the free time that you would have in any other job, you simply don't have time to pursue a second vocation. You will be engaged in the readings are very intense. Some of the readings are very dense, and it might take you a lot of time to prepare for the class before you come to the class. And if you don't read and come to the class, pretty much that class time is a waste for you because you may or may not be able to follow the discussions, considering that all instructors assume that the pupil have read the paper that they're assigned for that particular class. So in one sense, it's a full-time LLM. It requires a lot many reading hours and a lot many writing hours. I think that should have been clear by the curriculum design of the course. But one thing that is absolutely true, and there are no exceptions to this, and this is just not an opinion, but rather a fact, is that it is very, very almost impossible to pursue anything other than focusing on law, at least for the year that you spend with us. So I highly discourage you if you're coming to us with an expectation that you might be able to do something else on the side. It's just not possible.
Thanks. Yeah, this is not a part-time course. This is 24/7, actually, and that's what we say about all our courses in the university. Thank you, Nirish, for saying it so nicely. I would have just said no, it's 24/7, but yes. Okay, a couple of exam-related questions. I will read out both so that you can cover it both at the same time. What are the specific area we should look at for legal essay in the entrance exam? Right? And the other one is what exactly is APU looking from the students in the selection process?
Okay, the first one is easy to answer and might lead to my answer to the second one too. I'm sorry, the second one is easy to answer, might lead to the answer to the first one too. But okay, what are we looking for? We are looking for students who are curious. Number one, there is, if you've reached a place in your life where at least for the last couple of years you've been a curious person generally, you've been curious to understand society better, to understand relationships better, to understand any phenomenon around you better. There is this hunger. You're not somebody who thinks there's no point in trying to understand something deeply. and sharply than how you understand it already, then you're not a good fit for us. What we want are curious people. And when I say curious, I mean intellectually curious. Right? You might be a curious reader of comics or literature, which is perfectly fine, but you should also have an intellectual curiosity of some kind. Unless you have that, it becomes very demotivating for you to read through all the dense texts that are part of our courses. So there is absolutely that. Then, in addition to that, you must have at least got some of your basics in place. Because look, end of the day, I mean, we are all for access to education, etc. I mean, you should know this given our philanthropic nature of our organization. But more than that, I think it's end of the day, reality is that it's a master's program. It's not a bachelor's program. And we do build on certain concepts which we assume that you've read already as a bachelor student. So the second thing that we're looking for is a strong grounding in basics. I don't expect you to remember all the case laws. I don't expect you to suddenly have amazing memory recall of the statutes. But I certainly expect you to have understood notions of law. Conceptually, you should be aware, be critically engaged, and have had a good understanding of these notions that are essential to understand the law. Things like the notion of a right. What distinguishes a right from a human right? What distinguishes a natural school of law from positive school of law? These kind of things. Basic spiritual concepts and ideas about what law is. So, and that leads me to the third next question, which was what are we looking for in a legal essay? What should you read? I don't certainly think that you should make any special kind of preparation for this. Of course, if I were you, I can share how I would have prepared, and that may or may not help you because each of us have very unique ways of approaching exams, like any other exam. I would have not really. I don't believe in these sudden concentrated preparation slots for a certain exam. I think you've read 5 years of your course. What the legal essay tries to test is your general aptitude to that 5-year law course, right? If you take a concept that is current, so what we usually do is pick something that has happened of significance, of legal significance, that has happened in the last 1 or 2 years, and we try to ask you a question on that. And what we're trying to look for in your answer are how do you articulate your answer? How much conceptual awareness do you have? And how you apply those concepts that you're aware of in your essay. So 3 things, awareness of concepts, application of those concepts, and articulation. And also very some ideas about originality. How original are you? Are you merely just repeating and you've ratified certain things and you're just repeating and churning it out, or do you really have an understanding of it rather than just a memory of it? So this is not a legal essay is not an opportunity for memory recall. It's an opportunity for you to indulge, engage, and articulate your thoughts, your critical thoughts, based on your 5 years of legal education that we assume you have. So I'm not sure if I can prescribe a certain thing that you should study or read apart from take some stock of what has happened of legal significance in the last 2 years. So yeah, just relax and just be yourself and try to enjoy writing the legal essay.
Thank you. This is an interesting one. What's the difference between development sector and policy making sector? That's one part of the question. Then the other part is it continues to say, do private corporations reach out to lawyers for the roles of policy consultants?
Yes, the corporations do reach out to lawyers for roles in policy consultants. In fact, I'm aware of far too many instances of this happening. Although I would be a little cautious in saying that this has become a very widely sought avenue. It's certainly not as sought as, say, a commercial lawyer in a company. But there is that opportunity opening up. I know at least big companies like Microsoft, Facebook, all of them have a policy. In fact, even one of the big law firms in the country have now a policy team that works on that, and most of them are comprised of lawyers. So there is space for that. Now, as to the difference between development sector and policy making sector, I think it's easier to look at policy making sector because that's clearly a defined sector, right? You're not just looking at law for lawyering, but you're looking at policy, how we look at policy is what is the nature of the interaction of state with citizens. So how does a state make draft its agendas for this? And it could include law, but it could be things other than law also. Yes, so that's the policy sector. But development sector, I don't. It's comparing apples to oranges. First of all, unlike policy sector, development sector is not such well defined. Different people look at development sector in different ways. We look at it in a way of social change, which is again fairly wide. So when we talk about development sector, in our mind, at least here at Azim Premji University, some of us invoke or have in our mind organizations that are engaged in social change. So educational organizations like think tanks, policy making sector, right? And includes research on policy. But policy sector, we need more specialized organizations, right? So organizations that necessarily involve the state into their work and the art of statehood into their work. So there is a clear overlap, but policy being more applied in that sense, with applied to include in that sense, and development being more applied to include actors other than state far more closely.
Thank you. That was good. Do we want to name some specific think tank and research organizations that participate in the placement process?
One of them that participates in transformation process is Azim Premji Foundation. There are many other organizations too. There's now CSR has helped many companies to foster such organizations. Nilekani Foundation is another example. When it comes to law, particularly, there's Vidhi that engages in law policy space. There is CIS, Center for Internet Society, that engages in law policy space when it concerns internet. So there are both general as well as specialized organizations. Thomson Reuters, I know, has a foundation that engages in access to justice projects. Right? Yeah.
Okay. There's a simple logistics one. I will take that. Kindly inform about the date of the entrance exam. The entrance exam is on the 13th of March. Okay, so all of you who have filled the form will get the admit card and the notification of the date. And those who haven't completed the form, we would request you to complete the form, right? So that we can include you in the list and we will provide you the notification. So back to the questions. There's another one regarding the learning environment, and I will let Niraj answer that, and maybe I can add. As residential learning plays a vital role in the higher education, what is the academic aura of APU's campus and the library? And then what are the COVID managing mechanisms in order to, protect the students and so that learning doesn't suffer? That's the second. The COVID thing you can leave out, Niraj, but do you want to talk about the academic aura of the campus?
Yeah, academic aura of the campus, we try and make a campus that's very friendly, not just for students, but also for teachers. What we try to do is not try to break some of the hierarchies that are present in some very traditional universities in India. So that way our campus is an unusual space. The idea is to allow you spaces in the campus for more conversations, discussions, and debates that help you and encourage you to question things. So the aura is in one sense very academic, and the spirit of that academic aura is more in engagement with the subjects that you're studying, more curiosity, more exchange of ideas that you're engaging in. There's also now, we have a new campus, and that allows us to do far more extracurricular stuff. I just got an email this morning that our cricket field is ready, and very soon we'll have a student versus a faculty cricket match. I'm very excited for that. There are other spaces. There is a very nice discussion. There are these very nice discussion spaces in between campus that allows you to convene. I saw the students keep doing other kind of stuff like second-hand book circulations and arts and culture stuff. There are music rooms. So all sorts of diversity that you expect from a liberal arts kind of campus is there, at least in my understanding is there. And aura is again a very wide term, but I hope I'm trying to, my answer is somewhat clarifying your...
Good. Yeah, thank you, Dina. Yeah, it is very, very sort of, hyper energetic campus, because also because the undergraduate students are also there. So, and all of you sort of, live together, study together, eat together. So it's like really nice. And the clubs, we always try to keep account of the clubs, but we are always behind because a new club gets added almost every week. Okay, and the COVID mechanisms, don't worry about it. We have done all we can. In fact, we go beyond the campus. I mean, we provide COVID assistance to, because to the foundation, to a very large section of society. But within the campus, we have regular tests going on. Within the campus, we have testing facility, and we have isolation areas. We have medical care. We have a doctor available on, in campus all the time, on call. So yes, it's very much, we understand that the students come from faraway places to stay in our hostels and to study with us. We have people from students from as many as 29 states who are there with us. We know that at drop of the hat they cannot go back home. So we have to, even if they sort of contract the disease, they still stay with us, and we have everything in place to take care of that. So we haven't had we've been running in-person classes for a while now, and we've been able to do that, right? So there is, you don't need to worry about that at this stage. Yeah, okay, the next question is, does being from a different language background, will that be an obstacle at APU? I guess from a
Okay.
non-English background.
Yeah, yes and no. Because look, truth is that currently the LLM program is the medium of instruction of LLM program is fully English. All the literature that you will be exposed to is will be in English. All the class discussions are in English. All the submissions, exams are all in English. There is that we don't do any other language right now, and that's important because unfortunately or fortunately, I mean, it's a colonial hangover, but it is a common medium of interaction amongst we think, and it's funny that that's a reality, but that allows us to access students from more wider area of backgrounds that we speak English. That's that. So that in that sense, yes, if reading and writing might be difficult, and especially because in the nature of submissions and discussion, articulation is very important as part of the law program. So that is true. But I also mentioned no because the university recognizes that and is cognizant of it. So there are English language support courses. In case you want to join the program, you might want to also enroll in the English language support programs that are done at your external times, right? So these are support courses that are conducted outside of your usual class timings, and you will have to kind of keep up with that there. But either which way, my honest suggestion is that you have to take a fair call on where you stand on that language, right? If your command over language is fairly basic, English language support will definitely help you. But if your command over language is very, very scant, which means you're not so very familiar with English language, given that it's a one-year course, you might have to step up a bit substantially to be able to overcome that obstacle.
Thank you, Neeraj. And I think we're done with the questions. Now we also done with time. We are at the end of time. Thank you everybody for listening in. The video will be available as the YouTube link, which was shared with you, and then you can write to us at admissions@apu.edu.in for any other questions that you might have. Thank you, everybody.
Thank
Thanks,
you very
Neeraj.
much. Yeah, thanks, Sapna. Thanks everyone for patient listening. Bye.